Hello, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our fees are all based on your income, so that means that the less you make, the less you have to pay. Today, we're going to be discussing contested divorces in Massachusetts. What is a contested divorce? Well, there are two types of divorces, contested and uncontested. An uncontested divorce is where you and your spouse agree to all the issues in your divorce. So you have a complete agreement on all the issues, including child support, child custody, division of property, alimony, and everything else. That is an uncontested divorce because there's nothing that's being contested. A contested divorce, on the other hand, is any divorce where there's at least one issue, one live issue that is not settled between the parties. Sometimes it's many issues, sometimes it's all of the issues. But in any case, if you can't come to an agreement on every single issue of the divorce, it must be placed on the contested divorce track. The main difference between contested and uncontested divorces, quite frankly, are the three big things are it takes longer. A contested divorce takes longer. It's more expensive and it's more involved. Contested divorces start off by where one party files a number of documents with the court. So you have to file a complaint, you have to file a statement of finances, you have to file your marriage, a certified copy of your marriage certificate, and a number of other things. If there are children involved, minor children involved in the divorce, you have to file additional documents as well. You'll also have to go to a parenting class, both of you, and supply a certificate of completion. So you go and you file all these documents, you pay your filing fee, of course, and the court will give you a summons. You then need to serve the summons on the other party, on your spouse. So the service happens by you give it to a constable or a sheriff, and they go out and they physically hand the papers to the other party, to your spouse. It can be also left at their last known address and so forth if they can't get in-hand service. But in-hand service is the best way to go. They are now the defendant in the divorce proceeding. Now they have to file an answer to your complaint. The answer is a document they file with the court, and they respond to the allegations that you make in the complaint. When that happens, when they are served, automatic orders go into place. The automatic orders are to protect the marital estate so that nobody runs up the bill. You can't take out any extreme credit where it would harm the other party. You can't dispose of any property without permission of the court and so forth. You can't take anybody off of a health insurance policy or change a beneficiary to any life insurance or other financial instrument. So those are the automatic orders that happen right away. Soon, one party or the other is probably going to file for temporary orders. So what else are you looking for in these temporary orders? So divorce takes a long time. And during that time, you have to live your life. You have to live your everyday life. So you need to have orders in place establishing who has custody of the children, how much will the child support be, if there's any spousal support, how much is that going to be, who's going to be paying which bills, who's going to be staying in the marital home, and so forth. There are a whole number of issues that need to be put in place for the pendency of the divorce case. And those are orders that are entered by the court. You may have arguments that are made on both sides as far as what the orders should be, but they have the full effect that a final order does, but they're only temporary in nature. Then you're in the discovery phase. Discovery is basically an exchange of information between the two parties. It takes the form of interrogatories, which are written questions that have to be answered under oath. There are requests for production of documents, requests for admissions, perhaps, and depositions are also a possibility. So that's the discovery phase, so that you can find out exactly what the other party has for assets. That's one of the biggest issues in a divorce. And if there are children involved, you may be asking questions as far as that goes as well. So that's the discovery phase. At some point, there will be a pretrial hearing. Prior to that hearing, the parties are required to meet to discuss the issues that are settled, to discuss the issues that are live issues, and to see if there are any what who the witnesses would be if it goes to trial, and what the evidence would be presented at trial. If everything is resolved by that point, by the time you go into the pretrial hearing, a judge could enter an order at that point. But if there are any live issues, then you would have to schedule your case for trial. It's a very small percentage of divorces that actually go to trial. One of the reasons is that it's so expensive. It's very time consuming to prepare for trial, so that you have to pay in order to be properly prepared to go forward, to present your evidence, to cross-examine the other side as well. So the cost of a trial is an incentive to try to work out an agreement between the two of you. In any case, if you do go to trial, a judge will enter a judgment. Then you're in the nisi period. So a divorce nisi is basically it's a waiting period of 90 days from the time of judgment until the time a final order is entered. And that period of time, that 90 days, is sort of a relic of the past. It used to be that the government, feels that divorce is bad for society, so they were trying to slow things down and to try to give the couple an opportunity to reconcile, so that they don't go through with the divorce. So that's still possible, and that's what that's for. In addition to that, a divorce nisi period is also a time where if you find out that your spouse was, say, lying about the value of his or her assets, or has hidden assets as well, then you can bring that information back before the judge before a final order is entered. In any case, after that 90-day period, unless you take some action to stop the divorce, at the end, you don't have to go back to court. After 90 days, a final order is entered, and you are officially divorced from your spouse. So that's kind of the shorthand of what a contested divorce is in Massachusetts. As I say, it's more expensive, and it's a lot more involved, and there are many steps along the way. So you would certainly want to have uh, an experienced divorce attorney in your corner to give you advice and guide you through that process. As I said, at Afford Law, we do practice family law, which is divorce, among other things, divorce and criminal law. Our fees are all based on a sliding scale. That means the less that you make, the less you have to pay for our services. We're trying to give voice to the hardworking men and women of Massachusetts who have for far too long been ignored in the criminal justice and the family law courts. Is our that's our take on it. So we're trying to make ourselves as affordable as possible, so that you can have the experienced help that you need to get through this process. Please feel free to visit us at affordlaw.org. If you have any questions, feel free to book a free virtual appointment with me. I'd be happy to answer any questions you have on your specific case, because every case is different, every person is different. So this is just some general information. I'd be happy to try to help you out as much as I can. At Afford Law, we're making justice affordable. Thank you.